Hello, everyone, and welcome to our Women in Sectional Title webinar from a sweltering Johannesburg. It's great to be with you again, and I can't believe this is the last one for the year. So also to really thank PK of Octagon, Sectional Title Solutions, and of course, We Connect You, faithful and loyal sponsors. And we're really extremely thankful for their sponsorship for next year as well. So today we're talking about pets and policies, possibilities in your sectional title complexes. But before we do that, I really would like to look back, take a look back and see what we did over the year. We had a productive year. Hello, Serena. Nice to have you here. We had a productive year. And if you'd like to view any of these events, you can go onto our events page for Women in Sectional Title on our website. So for January, we started with New Year resolutions. It would be interesting to go back to that. In February, we talked about the dynamic landscape of electric vehicles, and we had our guest from Australia. In March, we looked at forecasting trends, and April, we spoke on insolvency in our sectional title schemes. In May, we looked at building, zoning, and development rights in sectional title. Still pose a huge problem at the moment from a rezoning point of view. In June, we looked at arrear levy lifelines. Then July, we fleshed out mediation and how mediation works in our sectional title schemes. August, the rise of the executive managing agent, that was an interesting one. And September, we spoke to the acting chief ombud about CSOS challenges and how the challenges were going to be remedied. In October, we looked at mental health and the workplace during Mental Health Month, and November, how to manage schemes more efficiently. So we are already now in December, and we're speaking about the issue that elicits the most emotion in our sectional title industry, and that would be the keeping of pets in sectional title schemes. Let me say at the outset, if you look at European legislation and certainly the condominium legislation, which is the most sophisticated in the world, you'll find that it's a matter of course that you can own a pet in a community scheme building. It goes without saying that this is part of your right as a homeowner to own pets. South African law has been somewhat different. And in the past, we've seen blanket bans on pets in sectional title complexes where you say no pets allowed in a scheme. And if 75% or more of your owners decide to amend their rules to that effect, then that is the law. Interestingly enough, I think we are evolving, and I think there's going to be a proliferation of pets in our sectional title complexes. So today, you've only got me. I'm going to be taking you through an article that was written by Professor Cornelius van der Merwe, fondly known as Coenie van der Merwe. I think it's an excellent article, and I would be very happy to share the article with you, with his consent. We're going to go through it as though it's a lecture. So I'd like you to grab a pen and keep your notes. You can type them up later, you can look at them later, but we're going to go through step by step exactly what needs to be atop of your mind when you're talking about keeping pets in sectional title, because there's so many different elements to it that you can often get confused. So we're going to categorize everything and go through everything step by step. So Professor van der Merwe, by the way, is a research fellow at the University of Stellenbosch, and he's also a professor emeritus at the University of Aberdeen, which is in Australia. He writes very well, really academic articles, and it's good that I'm going to summarize this for you. So we are going to go straight from the article. And then if we've got any time later on, you can ask some questions. So the issue of pets, we know, has always been controversial, and certainly fiercely contested in your complexes. I've had people paying hundreds of thousands of rands to use an advocate in the High Court in order to defend the fact that they can keep a pet. And then we've also got so much information which talks about your property value is actually going up and your market value is retaining their asset value and even increasing if you are allowed a pet in your section. And that's something I think that we really need to be mindful of, because I've had so many estate agents also saying, well, you know, if no pets are allowed, it's a lot harder to sell a unit. Taking into account and what Professor van der Merwe says is that there are physical, psychological, health benefits associated with pet ownership. People with pets are reported to deal better with stress, have lower blood pressure, lower cholesterol, that would be good for me, increased physical activity, a strengthened immune system, and a lower incidence of depression and loneliness. Well, there's also obviously a flip side to that, which we'll go through just now, but certainly South Africans, we love our pets. And there are reports that say that apartment owners are increasingly owning pets, which includes dogs, cats, fish, rodents, not so happy about the rodents part, birds and reptiles, while owning larger dog breeds is on the decline. So the keeping of pets in sectional title, this is when you can grab your pen. We need to look at it from the legislative point of view. That's our starting point, okay? So your pets rule, conduct rule number 1, and it's not number 1 without good reason, because it is an important issue, is the keeping of animals, reptiles, and birds. That's conduct rule number 1. And we know that the conduct rules go together with the management rules and, of course, are read together with the Sectional Titles Act. So in the Sectional Titles Act, you've got Section 10 of the Sectional Title Schemes Management Act of 2001. And that's read together with your conduct rules. We'll talk about what the conduct rules say. But Section 10 provides that the rules must be reasonable and must be applied equally to all unit owners, and that the chief umbud must not approve any amendment to any rule unless he's satisfied or she's satisfied that the new rule is reasonable and appropriate to the scheme. So it's conduct rules, Section 10 of the Sectional Title Schemes Management Act. And then thirdly, you've got the Community Scheme Service Act, Ombud Service Act. And here it talks about the right of the ombud to give an award to say to a certain owner that they have to take action to stop the nuisance of their pet or to remove the animal. In dealing with adjudication awards in respect of scheme rules, the CSOS Act provides for an order declaring that, having regard to all interests of owners in a scheme rule is unreasonable and it requires the body corporate to approve and record a new scheme governance provision or to take it away. So very often, somebody will come to my office, they will bring the rules with them and they'll say, there it is, it says no pets allowed in our complex. So what this is saying is you can approach the community scheme ombud and ask for an order to deem that provision invalid or unreasonable so that it can be taken out of the rules. So all these acts and the conduct rules conspire to explain or give an explanation to you of how you actually deal with the rules. So we'll go into it in a little bit more detail now. We're also going to be talking about New South Wales and what happens in New South Wales, because of course our act was taken from their 1961 Act, and we have really similar legislation, apart from the fact that their legislation is a lot more hefty. If you have to hold up their book or the act, it's huge. It's got so many more sections than ours. Also, the United States Uniform Common Interest Ownership Act is looked at as well, specifically with therapy dogs, Professor van der Merwe says, because it's considered the most sophisticated condominium legislation in the world. Okay, so today we're talking about the requirement of written consent from trustees, which must not be unreasonably withheld. We're talking about a validity of a rule completely banning pets. We're going to go into that. Also, the conditions restricting, the restrictions and conditions on having a pet. and we're talking about assistance and service dogs and cats and other creatures. Okay, so let's start now with the written consent of trustees, because in your model conduct rules, which is conduct rule 1, it provides that owners cannot have pets. This is our first port of call. Owners cannot have pets without the trustees' written consent, which written consent shall not be unreasonably withheld. If you're a managing agent, you've heard this 100 times. I've said to you that in some states, it's a reasonable thing to keep a pet, but in South African legislation, you're not guaranteed this fundamental right. It's got to go through certain processes. And your locus classicus, your case law, which is the one that if you're been in the industry for a while, you know, is the body corporate of the Laguna Ridge scheme. And those rules in that scheme said, no animals, reptiles, or birds in cages shall be kept in the sections or on the common property unless expressly permitted in writing by the trustees, and then only in accordance with any conditions stipulated by the trustees. So this is Laguna Ridge, Laguna, Laguna Ridge versus Dorsey. So Mrs. Dorsey was an elderly lady who wanted permission to keep her new Yorkshire Terrier in the scheme. It was a very big building. It was 18 stories, but with only 65 units. And the trustees decided that they didn't want to create a precedent, and they felt that it wasn't suitable to have a dog there. But then when they went to court, the court found this approach unacceptable and said that the trustees had to look at every single matter or case or application they got on its own merits. Means that the trustees had to sit down and put their minds to whatever it was. In this case, they held that the dog didn't bark, it was carried everywhere that it went. It was a very, very, very good little dog, and it didn't constitute in any way a nuisance to the neighbors. Also, Mrs. Dorsey was a lady by herself, and there was certainly a lot of loneliness, and she really, really felt that she needed this dog to keep her, to keep her, well, not lonely, let's put it that way. So the court held that the trustees' decision was actually reviewable under common law, and that they set it aside, this decision of the trustees, because it was ultimately grossly unreasonable under the circumstances, and that they had failed to apply their minds. To refer the matter back to the trustees would just prolong her anxiety, and they looked at all the relevant factors. They said that the respondent must be given leave to keep her dog under specified conditions, and this is where we can glean from this important case that the default position or the default rule is that owners are entitled to keep pets in the scheme unless the trustees refuse on reasonable grounds to grant written approval for the pets to be kept. So that is what you're always going to go back to. We'll talk about a scheme where it says absolutely no pets allowed. That is coming up. So discretion has to be used, and that's taken further in one of these CSOS adjudications, which is Coenie, not George Clooney, this Coenie, C-L-U-N-Y, body corporate, versus Deerwald Barkhuizen. And in this case, the adjudicator had to decide whether the trustees had exercised their discretion reasonably in ordering the respondent to get rid of one of the 3 dogs, where the scheme rules stipulated you can keep pets with the trustees' consent, but you can only keep 2 pets, not 3 pets. So the adjudicator found that the trustees were obliged to apply their minds to the matter, and that each matter must be considered on its own merits and facts. So that's again, and in this case, just as a matter of interest, the ruling by the adjudicator was that they had to get rid of the 1 dog in this case, because it was reasonable that there should only be 2 pets. If everybody could have 3 pets in a complex which is not configured in the correct way, then you might have a problem there. Okay, then you go to Governor versus Naidu. Here, the applicants appealed against the trustees' refusal to allow them to keep an African grey parrot and a small Jack Russell. The court here found that the reasons for the trustees' refusal was that other sectional title owners in the phase where the guide applied from were against keeping the pets. And the body corporate, wasn't happy with all of this, and it would create a precedent. Again, as soon as your trustees are starting to say, well, it's going to create a precedent, then everybody's going to want one. Then you can start seeing that, that's going to be ousted by the CSOS. They're not interested in that argument. So in Laguna Ridge, it was exactly the same. So in this case here, the court had not seen the parrot and dog to assess what possible nuisance they could pose and weren't familiar with the layout and the common areas. So the court did refer this matter back to the trustees to reconsider their decision, taking in all the relevant factors into account. So it's not like you're ever going to get somebody saying, no, you can't have a dog just out of hand. There has to be consideration. So those are the cases that bring consideration to the table. New South Wales. So New South Wales is where Sydney is in Australia. In New South Wales, they really do things properly, and they've had all sorts of rulings up until 2020, where on the 12th of October, you can note this down, 12th of October 2020, there was a landmark case in Australia, and it was called Cooper versus the Owners. Cooper versus the Owners, and it was under Strata Plan number 58068. I think they have numbers when they're dealing with these matters. So in this case, it was held that a complete ban on pet ownership in any complex is harsh and unconscionable. They used the terminology that it was contrary to public policy, and they said that the people were being forced to look at this, and it wasn't fair. And what followed after this, which was again a landmark case, was that the Department of Fair Trading in Australia, because when they do something, they do it really from a regulatory perspective. As we say in South Africa, they're very parrot. They put out a full survey in 2021, setting out, asking the Houses of Parliament within 6 months to actually table a report so that they could really get to grips what people felt about animals and, the well-being of animals and their owners. So in August 2021, the New South Wales Department of Fair Trading published a report titled Review of the Keeping of Animals in Strata Schemes in New South Wales. So they had a look at this, and it looked as though they took these things into account as well. They said that it's reasonable to keep animals in a strata title building unless there's unreasonable interference with another person's use and enjoyment of their property. And these kind of things, where there's interference with use and enjoyment of somebody's property. Remember, in common law in South Africa, you're entitled to the peaceful and undisturbed possession of your property. So when a pet acts like this, first of all, makes a persistent noise to the degree that the noise unreasonably interferes with the peace, comfort, or convenience of another occupant, or 2, repeatedly runs at or chases another occupant, a visitor, or an animal kept by another occupant. 3, attacks or otherwise menaces another occupant, a visitor, or an animal kept by another occupant. 4, repeatedly causes damage to the common property or another lot. Or 5, endangers the health of another occupant through infection or infestation. Or causes a persistent offensive odor that penetrates another section or the common property. Or for a cat, the owner of the animal fails to comply with Section 31 of the Companion Animals Act, that's in Australia. 8, last one, for a dog, the owner of the animal fails to comply with a section of the Companion Animals Act, or the dog is declared to be a menacing dog or a dangerous dog under the Companion Animals Act. So the new strata pet laws, just to summarize, make it extremely difficult for strata buildings to prohibit pets and refuse applications from pet owners who want to keep a pet. In the past, owners had to jump through hoops to keep their pets in apartment buildings. Now, the trustees or strata councils must justify their attempts to ban pets within these new legally defined parameters. Okay, so that is where we start now, looking at changes coming in terms of our community scheme, Ombuds Service, awards, and the law. Bear in mind, nowadays, you're not actually going to be able to take pet adjudications or pet disputes through to the courts. I've seen one or two matters already in our practice where they've kicked the matter out of court. We have case law to that effect as well, where the courts are saying that the Community Scheme Ombuds Service is a regulatory body, and the Community Scheme Ombuds Service must deal with these kind of disputes. My view and my feeling with the Community Scheme Ombuds Service at the moment is that they're looking very carefully at the legislation and all the new happenings in Australia, as well as around the world. And you've had a few awards where you've seen that they're leaning towards trying to keep pets in schemes, unless from a geographical point of view, it's very difficult to keep pets in. I've seen one adjudication order where they said, no, you're not allowed pets because the complex was situated in a nature reserve. So they were worried about dogs running after the birds that were protected. There are circumstances, but I think for the most part, we are looking at, having more pets in our schemes. We've also had a Gauteng High Court decision in the matter of Ireland, as in the country Ireland, Island Gardens versus Finnecac, which was a legal wrangle in the Gauteng High Court a while ago. And the chap there, Isaac Finnecac, was not happy with the rules of the scheme, which he said were discriminatory. So the rules of the scheme there said that you could keep dogs, but you weren't allowed to keep cats. And the reasons they put forward were that cats could not be properly contained. People were finding cats, in their sections, lying on the bed of one of the children who had very bad cat allergies. And, he wanted his cats very badly, and he felt so strongly about it that he went to the Community Scheme Ombuds Service and he asked for the rule, which I mentioned before, to be declared invalid, unreasonable, unconstitutional, and discriminatory. And in fact, the adjudicator felt the same. And she basically, the court. The court felt the same, and the judge there, it was a lady, said that it's discriminatory. You've got to, the rules have to apply equally. That's something you can always use as a portfolio manager about almost anything. It's something important to know. And that's section 10.3. The rules must apply equally and consistently to all owners. So if I'm a cat lover and I'm an owner, I should have the same rights to own a pet as the doggy people. I don't know, you must tell us what you are. You're a cat person or a dog person. I've also heard of cats where they're in complexes where they scratch cars and they sit on cars. I mean, I'm more of a dog lover myself, but I think cats can be quite tricky in sectional title, but certainly they're not entitled to be excluded. There was an adjudication award, and I've been looking for it. When I find it, I will definitely send it through to you, all your email addresses. There was an award where it was held that pets were allowed to be on both floors because the trustees had said you can only have pets on the ground floor because they're gardens, and then you can't have on the first floors, on the second stories. And an adjudicator there also held that that wasn't allowed. If you're going to have pets in the complex, you must allow pets. in the entire complex. I must tell you, I'm also dealing, it's confidential. I mean, I can't give away the full details, but I'm dealing with a matter right now where the trustees are saying that my client is not allowed to keep his small little dog, highly inoffensive little dog, in the scheme because there are too many dogs on the one side of the scheme. If somebody had asked for permission to keep a dog on the other side, it would have balanced the situation out. And there would be too many pets in one particular space, which I don't think will fly with the community scheme ombud service again. So many of our trustees are also telling their estate agents, when you sell a property, make sure that you tell them this is not a pet-friendly complex, even when there are pets in the scheme. And of course, you can be taken to the Equality Court for that as well, because it's you can't be treating different applicants in a different way. So be aware what your estate agents are telling people. And also I heard yesterday actually, an estate agent came to speak to me about something, and the trustees were trying to tell her who they could sell to and who they couldn't sell to. I mean, obviously, you do want people who are moving in to understand your scheme and what is correct in your scheme and how you want to run your scheme, but you're certainly not able to start curating exactly who you want to be in your scheme, in as much as you probably would like to. Okay, so let's move on now to get to grips with this banning story, this absolute ban. So the Cooper's case was the first case which said in Australia, you cannot ban animals. And I've seen so many, and I've given advice that you can in the past, say no pets allowed in the scheme. However, things have moved on and things are changing at quite a rapid pace. So Professor van der Merwe says, in my opinion, the following reasons could be advanced for holding a rule that prohibits the keeping of pets in South African sectional title schemes unreasonable and therefore invalid. So these are the reasons, and the reasons actually come out of the Cooper case. The Cooper case said that an outright banning of pets was harsh, unconscionable, and oppressive. Harsh, unconscionable, and oppressive, and therefore invalid. So he says, in terms of the South African Sectional Titles Act, a sectional title owner acquires separate ownership in his unit, his section, and this entitles him to use or enjoy the ordinary incidents of property ownership, balancing the interests of all owners and occupiers in the scheme. And the keeping of pets should be considered an instance of property ownership in view of the advantages attached to having pets. Consequently, says Professor van der Merwe, the chief ombud or the court should reject a rule providing for a blanket prohibition on the keeping of pets as unreasonable. This applies only to a blanket prohibition and does not exclude a rule allowing pets to be kept subject to certain conditions. Okay, so it's immaterial, says Professor van der Merwe, whether such a no pets rule has been adopted already or maintained by a large majority or even unanimously. So if every single owner with an 80% quorum says we don't want pets, and some other guy comes along and says, this ban on pets is unreasonable, it shouldn't stop him. The very purpose of the reasonable requirement is to ensure that minority rights regarding the use of residential property must be considered objectively and should not be overridden by a contrary majority view. Very interesting. And thirdly, he says, the fact that sectional title owners acquire their interests in the knowledge of the laws and limitations does not mean that somebody buying into the scheme may not challenge a rule that is unreasonable and not equally applicable to all owners and occupiers under the Act. Scheme rules adopted unanimously or by majority may be declared invalid if they infringe a statutorily prescribed standard, irrespective of the knowledge of the purchaser. You can't say, well, you knew that there were no dogs in this complex when you bought because of the rules. Well, you know, he argues against that. So Prof. Merwe says that certain South African legal practitioners disagree and maintain that if the conduct rules have been amended to include a no pet rule, the matter becomes contractual. He says, I don't agree that the matter is purely contractual and that a purchaser buying into the scheme would be bound by a no pet rule. The rules as prescribed and amended must be interpreted as laws made for the body corporate of that scheme. The view that the rules are contractual in nature is based on a mutual agreement, the understanding of a mutual agreement between the sectional title owners. And these rules differ from an ordinary contract because in our rules can be amended by a special resolution. That's not normal. So all of this contractual, the contractual position is contrary to the basic principle of freedom of contract. He says that these are different laws. This is a unique, autonomous, statutory body, a body corporate is. It's unlike a voluntary association or a cultural association. And even in the Cooper case, the judge there accepted that the Act there creates a statutory framework within which a type of local community can be created and administered. So they both argue that it's not contractual, and that is why. So a rule containing a blanket prohibition on the keeping of animals, they say, is unreasonable and invalid because it doesn't provide a mechanism by which the body corporate can consider the individual circumstances of each owner and can unreasonably and unnecessarily precludes the exercise of the ownership rights of use and enjoyment. It doesn't permit a balanced consideration of the many aspects of the issue. Such a rule only operates in the interests of sectional title owners who oppose pet ownership. So that is Professor van der Merwe's take on banning completely. And I've seen one or two CSOS adjudications that are going with that interpretation. Okay. Let's talk now about the standard rules, though, where it says you can obtain trustees' consent, but there are restrictions on ownership. So it is within the powers of the trustees to attach reasonable restrictive conditions to their approval and to withdraw their permission, certainly, if the conditions are breached. And one of the things that, in my case, the trustees were mentioned, they said, we're not allowing pets because it's too hard to get rid of them. Well, unfortunately, you know, there are processes and you would need to go through those processes, but it's no reason to disallow pets into a complex. So examples of reasonable conditions are that dogs are allowed on the common property only when leashed. The animal may not cause damage to the common property. They may not defecate on common property or harm or cause nuisance to other residents or animals. And the withdrawal of consent must be on reasonable grounds and must be implemented by the rules of due process. So nobody is going to be allowed to come into your section and grab your dog and take it elsewhere. Yeah, Veet says, what about insisting cats and dogs be chipped? Yeah, chipped, definitely. That can be a reasonable condition. Absolutely. There's no problem with that. I did see the holiday question. We'll come back to that at the end. Chipping is absolutely fine, 100%. You can also, the dogs and cats can, certainly the neutering provision is also reasonable. But is it reasonable, for example, to say that an animal must be a certain height? You know, I've seen those conditions as well. It must be more than 20 centimeters. Well, there was a CSOS adjudication which held that a Great Dane was allowed to stay. It was over certainly 20 centimeters, but it had a very peaceful nature. Generally, they around the whole day. and it shouldn't only be for small dogs. There are large dogs with a natural temperament to live in a sectional title scheme. I've also had instances where you're putting conditions on these things which say you're not allowed pets of an aggressive nature, but then they fail to say what those pets actually are. Then you've got to go into all the questions of, what is the Rottweiler, the German Shepherd, is it aggressive? And then, I mean, we've had so many adjudications about what dog's aggressive and what dog isn't aggressive. Okay, so basically also number of pets, the height of pets, all that type of thing. So you can also look at Abraham versus the Mount Edgecombe Country Club estate, which that's near Umhlanga. It's an eco estate with 890 residences. And there an application to keep a St. Bernard dog was refused on the grounds that when the dog grew, it would weigh somewhere between 55 and 80 kilograms, and the reasonable kilogram size in the rules, they said it can't exceed 20 kilograms at all. Okay. So there the judge found that the rule was clarified, and he concluded there that the applicants had to remove the dog from the estate within 3 months, but obviously the dog was also causing some other extra trouble. Okay. So from that point of view, also there's a question about feral cats there too. Feral cats become an incredibly big problem in our complexes. It really, really has. And unless you can link a feral cat to an owner, they're really not allowed to be on common property. And I think there's got to be some sort of policy within your rules which talk about feral cats, because otherwise, things can go pear-shaped. Seen too many problems in these complexes, and there are organizations that will come in. And certainly some of my schemes have said, okay, we've got 6 feral cats, and there will be somebody accountable for each one of those feral cats. But possibly something to pop into your conduct rules as well. Then something quite interesting, we're talking about assistance pets. So we know in our rules, in our current conduct rules, you have deemed consent of the trustees to keep a hearing or assistance dog. So you don't have to even make a written application to keep a hearing or assistance dog. And what Professor van der Merwe says is that he says, I submit that this sub-rule falls hopelessly short of regulating this matter adequately, and that lessons in this regard can be learned from the comparable Australian jurisdictions of New South Wales, Queensland, and the Canadian jurisdiction of British Columbia. So I think that's, it is. It's really a very loosely worded rule. I think it's worth strengthening it and concretizing that as well. I think we need to look at that. What is an assistance or hearing dog? I mean, I've had people saying that little Maltese poodle is an assistance dog for an ADHD child. Is it just a Labrador? Is it, do we have Malinois who are sort of action-related dogs that can assist with also sniffing out disease and illness, or if you need to be taking your diabetes medication? It's really, really not clear enough at all. As something interesting, which was in Professor van der Merwe's article, spoke about miniature horses as being part of condominium legislation, that you're entitled to keep miniature horses. They live longer than dogs. There are certain cultures that do not like dogs. They don't like dogs for religious reasons. And these miniature horses are very good assistance dogs for people with walking, that they can hang on to this little miniature horses, these horses that are trained. Also, he speaks about capuchin monkeys in the States, in condominiums. He says, the United States also formally recognizes that capuchin monkeys can be trained as assistance animals to help pick things up, open doors, turn on light switches, turn the pages of a book, operate microwave ovens, open bottles, and even wash their owners' faces. They can help people with quadriplegia, spinal cord injuries, severe injuries to their hands and arms, and multiple sclerosis. They undergo extensive training before being placed with suitable persons with disabilities, and monkeys' working life can span 25 to 30 years, which is 2 to 3 times longer than a guide dog. That may help my case at the moment with a little marmoset monkey, where a tenant owns the marmoset monkey, and the owners are not happy about the marmoset monkey. So we'll have to see about that. Okay, let me just see if there are any other questions. What about holiday makers bringing pets? Well, again, I think that would need to be stipulated in the rules, and if the time is temporary and that they're keeping to the rules, again, I think that there would have to be application made, Jennifer, before any animals are just brought. I don't think you can just pop your animals in the car, or even nowadays on the plane, and bring them to your holiday destination. I think that could cause all sorts of problems. Anita says, if Professor van der Merwe rules that the sectional title rules are a freedom of contracts and not contractual, then how does this carry over to other rules, not only pets? Example, noise such as drubbing. And if he states that 220% vote can overrule the rules contrary to 80%, how does that carry on? I'm not 100% sure there what she means, but basically, yeah, I think the fact is that what he's saying is that I didn't contract when I entered into this complex, I'm just entering this complex. You guys have contracted. The fact that you've contracted doesn't mean that that rule is correct. I think that's the point. And any owner, they don't need a special resolution. They don't need a unanimous resolution. They don't need anything. Any owner can approach the community scheme ombuds service to override a rule that is unconstitutional, contrary to public policy, discriminatory, controversial, whatever it is, and the community scheme ombuds service has the right to decide on those kind of things. So let's just have a look. Feeding of birds, Diane. Yeah, so birds also. Birds are a problem. I mean, you've got certain diseases, streptococci diseases, which are created when you've got pigeons and doves that are conglomerated in sectional title schemes. It is in the book that Corin, Blaze, and myself authored. We had a whole chapter on it, where you do have people who get very, very ill, and it's usually upper respiratory tract infections where birds are concerned. So I don't particularly think the feeding of birds in a scheme needs to be encouraged or even allowed, quite frankly, because of the potential dangers that it causes to others in a scheme. Again, that can be regulated probably, but yeah, to me, I think you're just, causing additional headaches that you don't really want. Also, here we've said how to deal with Egyptian geese. Kath says that breed every year and take over the pool and garden, defecating everywhere, and you have an owner who threatened the wildlife gentleman who's now too scared to remove them to a wildlife sanctuary. No, I think it's quite an interesting question. But I do think there are certainly those organizations and institutions who are authorized to deal with these kind of problems. And certainly one owner threatening the wildlife person needs to be solidly put in their place and needs to be told to sort of wind their neck in, so to speak. I don't think that any one person can hold a body corporate to ransom on anything. The trustees, are in charge. And so often you find that at the moment, one owner is placing trustees on the back foot. Trustees need to know their rights. They need to understand the correlating obligations that they have, as well as the other owners, and they must take it on. At the end of the day, there are people that are in positions of authority that can come out and actually assess the situation from these wildlife organizations. And certainly there are places for these animals. But yeah, I know Egyptian geese create a major problem in a lot of the big schemes, and the lodges need to be dealt with. Interesting. I think I might look further into that for sure. Right, so we've gone into our what about assistance cats? rules only talk about dogs. Karin, yeah, are you a cat person? I'm more dog person. I'm not sure about cats. I don't know that you can get cats to assist you, you know. Cats are quite, you're quite snooty. So, you know, if you can organize that, Karin, then yeah, I'll be very impressed. There are many other animals considered assistance animals, absolutely. And that's why we've spoken about these little monkeys, miniature horses. And that's why we have to have fresh perspectives in sectional title, remain open-minded, and look at other jurisdictions in the world to see what they're doing. But I think there will be more pets. I know managing agents, you're shaking your heads because it gives you more hassles. I understand that. But I believe that that is the way that things are going. So to end off, I'd like to say to you, thank you very much to all of you for your loyalty and commitment. I see so many names on my sheet every time I get emails. I see your names. I appreciate those of you who are loyal and consistent, and those of you who are new. Please keep supporting our Women in Sectional Title platform. We're looking at maybe gaining new sponsors and getting more managing agents on board to assist us in terms of getting the word out. I wish you many blessings during this festive season. If you are traveling, please take care, come back to us safely, and get ready for 2025, where I think there are a lot more exciting initiatives, certainly on this platform and in our industry. So thank you again, and lots of love to you all. Take care. Bye-bye.